Good morning. Are you Brandon Jamal Clayton?
Yes, ma'am.
And let's see, will your client waive the formal reading of the indictment and the motion?
Go ahead, Your Honor.
Mr. Clayton, in cause number 26 DCCR 0229, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from January 5th of 2026. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand?
Before this courtroom session even begins, multiple defendants are about to learn just how serious the consequences of their decisions can be. From gun-related felonies to probation violations and shocking criminal allegations, today's docket moves fast, but the outcomes are anything but small. One defendant will plead guilty to discharging a firearm. Another will see a decade-long sentence immediately triggered, and further down the line, someone accused of crimes against a child will make a decision that could determine the rest of his life. What's fascinating about hearings like this is how quickly the justice system moves when defendants accept plea agreements. But every yes ma'am or true you hear in this courtroom carries enormous legal weight.
If you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in that case.
No objection.
It's admitted. Is there any evidence that Mr. Clayton's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to find you guilty at this time, of deadly conduct, discharging a firearm. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22, 39186, I have a first amended motion to revoke your unadjudicated probation.
Judge, count 1 is, if we did 1 and 8, 1 is failing to report, 8 is the offense for which you just pled guilty.
Thank you. This motion shows that you were placed on probation June 8th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And the state's elected to proceed on counts 1 and 8. Count 1 alleges you violated your probation by failing to report as directed to the probation department July 2nd and July 17th of 2025. And is that true or not true?
True.
Count 8 alleges that you committed that new offense of deadly conduct on January 5th of 2026. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 8 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes.
I also have some documents in this case that the state's marked as exhibit number 1 that have your signature on them. Before you sign these, did you go over them with Mr. Parker? And did you fully understand them as well? And you also understand, if I follow the agreement in this case, you'll also be waiving your right to appeal. State tenders number 1.
No objection.
It's admitted. In cause number 22, 39186, I'm going to find that you entered your pleas of true to counts 1 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you in each of these cases, they'll run concurrently, which means together at the same time, if I didn't already say that. I'm going to hand you in each of these cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. Also, I am going to find in cause number 22, 39186, an affirmative finding of a deadly weapon. I'm also handing you the trial court a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here.
Yeah. Not me.
Give me just a second to get these pulled up correctly. Yeah, I'll do the first one if you'll print the second one. If you'll print 0493. Please, ma'am. Let's see. There's no agreement, though.
We're going for the court.
Okay. All right, sir. So is the state not, he's going to plead true to those, but
We're pleading true to 3, 4,
right.
5.
But so what's the status of the,
The other ones, Judge, so I have not, no fault in the state. I have not received the videos and some other evidence from it. In
okay,
reference to the actual offenses.
right?
I'm not saying when we come back, he doesn't plead true, or they're gonna have to bring their officers.
So we're going to go through all of
Right.
the counts. He's going to plead true or not true to
Right.
whichever ones.
But I mean, once I get all the discovery, then I may change 1 or 2. I just want to push it along because we agree with some of most of the allegations.
Well, and okay, so here's the thing. If he pleads not true to allegations of new offenses, then I'm going to set it for hearing. But I'm going to make time in our schedule for a hearing where officers would come when it sounds like they may not have to come.
And prior to that, I will
No,
let you all know.
yeah, no, how long, do you have that information? Does the
I
state?
think we're getting videos copied for him from these new offenses.
Okay, we'll reset it 2 weeks. That way we can know everything ahead of, yeah, we're not gonna
Yes.
piecemeal
If we
it.
do it 1 week, 2 weeks, I'm not going to be here. Second, the 25th.
Are they copied already?
I don't know, Judge. They probably are, to be honest.
Is that something that can get bumped up just since he's in custody and so we can get it moving forward? Here's, okay. I'm gonna reset it. Probably 3 weeks or so. If you get the videos this week and y'all have some agreement, call the court, we'll bump it up to next week. Otherwise, that gives you time to go out, go over everything with him, and then we'll get pleas of true or not true once you've seen everything.
I mean, the only thing I would submit to the court is there has to be an updated PSI anyway. I will request an update.
Yeah.
PSI.
Yeah, he's not gonna plead not true to something that we're gonna maybe change our mind in a week because you look at the videos. So I'm gonna reset it, look at everything. Then we'll get it taken care of. All right, you can go back with the
I'll
bailiff.
be back and talk to you.
Okay.
All right, are you Sulu Hampton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
Here we go, Honor.
Mr. Hamden, in cause number 24 DCCR 0759, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for a lesser offense of evading arrest or detention. I guess that really should say,
Yes, Sharon, we should strike with a motor vehicle.
any objection to
No
the
objection.
amendment? Did that. All right, so is the lesser offense of just evading arrest or detention, a class A misdemeanor? That was a 2-year deferred probation and has been extended for a year. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you provided a urine sample January 21st of 2026 that tested positive for methamphetamine, amphetamine, and tetrahydrocannabinol. And is that true or not true?
Yes, ma'am.
True or not true?
True.
And then count 2 alleges that you failed to pay your court assessed fees as directed. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hampton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of evading arrest or detention. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, sir, is it Ledet or Ledet? And you are Carl Ledet?
Yes,
And Mr. Ledet, in cause number 25, DCCR 0579, you're charged with a special degree felony of an aggravated assault of a child, aggravated sexual assault of a child, from August 1st of 2024. Now, what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 25 years up to 99 years or life in prison without the possibility of parole. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in the institutional division of the Texas Department of Corrections, obviously with the opportunity for parole. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Ms. French, is there any reason to believe at this point that there would be any change in that offer?
No, Your Honor.
All right, so I do want to make sure you understand, Mr. Ledet, that after today, there won't be, this offer will be off the table. You understand?
Yes, ma'am.
So what, Mr. Ledet, Mr. Parker represents you now. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Parker, you're released. Mr. Ledet, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes, ma'am. Thank you. Nice.
All right, sir, you can go back with the bailiff. Travis Lewis, Mr. Parker. All right, sir,
Good.
Travis Lewis. And will your client waive the formal reading of the indictment?
He will, Your Honor. United States elect and proceed under 1244 of the Penal Code and punish this offense as a misdemeanor.
Thank you, sir. Mr. Lewis, in cause number 25, DCCR 0014, you're charged with the state jail felony offense of credit or debit card abuse, and that's from November 29th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, expulsion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. And I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Yes.
You got it. You should have. Thank you. Thank you. Here.
Good morning.
Good morning.
Are you Mercedes Sias? Answer out loud, yes or no, please.
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Sias, best you can, raise your right hand for me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, ma'am. You can put your hand down. Ms. Sias, in clause number 18-29442, I have a motion to revoke your community supervision. Shows that you were placed on probation January 7th of 2019 for the state jail felony offense of driving with a child passenger. And that was a 2-year term in the state jail prison that was probated for 5 years and extended for 2 years. Is that correct?
Yes, ma'am.
This motion alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, ma'am. I had a lot.
Is it
True
Yes,
or not?
true or not true?
It's true.
Thank you. And we'll go through the reasons and explanations at another date, okay? Today, I just need to know if it's true or not true.
Okay.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of December 11th of 2025, you were $6,707 behind in your fees. Is that true or not true?
True.
And count 3 alleges that you failed to make monthly fee payments in the minimum amount of $50 as directed by the court. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and ask the probation department to do an updated report. That'll give me more information about what's been going on since we were here last, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he'll present it to me on your behalf when we come back.
Yes,
All right.
ma'am.
You can go back with the bailiff.
Okay.
Yes, not excused.
Thanks.
Miss.
With Mr. Smith possibly setting or asking for a PR bond. He is on deferred probation.
No,
So
it's on
according
strike.
to,
Deferred.
Hold on.
It's deferred.
It's deferred.
Right, yes.
So here's what I would ask, just so that everyone has an opportunity to prepare for any hearing.
yes, ma'am.
If you'll get something filed today, we can
Yes.
set it next week.
Okay,
Mr. Smith, if you will get with the whatever agency has not turned that over yet, explain to them what's going on with this case and what's about to happen. I don't know if that will encourage them to get something over more quickly. I know there's probably information they're still gathering, but we'll get that filed today. We'll
Yes,
get it
ma'am.
set next week for a hearing on the bond on this case.
Yes, ma'am.
Okay, I don't think I'll have a choice but to give some type of relief at this point.
Yes.
okay. Thank you,
Okay.
Your Honor. Okay. See you next week.
All right, we'll reset it one. Mr. Reynolds on Xeric trustee. Good morning. Are you Xeric trustee?
Yes, ma'am.
Mr. Trustee, clause number 25 DCCR 0981. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 19th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0982, you're charged with the first-degree felony offense of aggravated robbery. And that's from June 19th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand?
Yes.
In each of those cases, I have here on the tablet some documents that you've signed with Mr. Reynolds showing that the district attorney's office has made offers in your case if you wanted to enter pleas of guilty for 15-year terms in each case that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. Let a jury decide if you're guilty and let that jury decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and move forward with trial?
Yes, ma'am.
All right, is there any reason to believe that there's any other information out there that would change that plea offer?
Not at all, Judge.
So I do want to make sure you understand, Mr. Trustee, that after today, I will not accept this plea offer or agreement unless there is some new evidence that comes to light that Mr. Reynolds or your attorney, or the state's attorney doesn't know at this point. And so we'll get it placed on that trial docket and Mr. Reynolds will begin preparation for trial. All right, you can go back with the bailiff. And you're Eric Seagrass Jr.?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Seagrass, in cause number 25 DCCR 1836, you're charged with the second degree felony offense of burglary of a habitation from October 24th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
The documents that you signed today, did y'all go over those?
Yes, yes. Your
And
Honor.
do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Absolutely.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
Hold on. Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Seagrass is not competent?
No, Judge.
All right, sir, did you have a question?
Yes, ma'am. About my mental health, I was wondering, would I be sent to like spinal tap so I can get the right kind of medications?
So here's what's going to happen. Absolutely. If there's any kind of issues, that's exactly what probation is for, is to help you get past any issues. What I'm going to do is reset your case for sentencing. And the probation department will do a pre-sentence report. And I'll ask them to do any kind of evaluations if they can between now and then.
Yes, ma'am.
Any help that you need, I'll order it as a condition of your probation. And so we'll take care of all of that when we come back for sentencing.
Because I'm schizophrenic and I wanted to get help with like mental health use.
All right, we'll get yes, we absolutely, I appreciate that you're letting me know that. Probation is over there now. She's making a notation of it so that they'll discuss that with you when they come out to do that pre-sentence report, and we'll have a plan in place when we come back for sentencing.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you, Judge.
I don't know if I said everything I was supposed to. I'll say it for sure. When we come back, I'll be say it.
This courtroom session is a powerful example of how quickly multiple criminal cases can unfold in a single docket. We saw a defendant accept responsibility for discharging a firearm and violating probation, ultimately receiving a 15-year prison sentence when those cases were combined. Other defendants faced consequences ranging from short jail terms for probation violations to serious felony charges heading toward trial. But perhaps the most striking moments came when defendants had to decide whether to accept plea deals or risk going before a jury. Choices that can literally shape the next several decades of someone's life. Courtrooms like this reveal the balance judges must maintain between accountability, legal procedure, and public safety. Every plea, every ruling, and every sentence carries long-term consequences for the people involved. If you found this case as fascinating as we did, hit that like button, share your thoughts in the comments about which ruling surprised you the most, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal analysis.